Hey everyone, it's Rob Ryder on Sunday, December 2nd, 2018. Unemployability isn't a four-letter word. I'm talking about veterans claiming entitlements and what it means to the United States. And I kind of direct that to people I've talked to that, retirees from the military that think it's kind of crazy that somebody who only has 2 years in the military could be entitled to a pension for unemployability that would pay them $3,000 a month. $3,000 a month, full medical, dental, and give you an ID card, such as this one, right? So this is the ID card they get if you are considered unemployable, totally disabled for pension purposes, and basically it's putting you back in the military. Expiration, indefinite. You are in the military for the rest of your life. It's like you join a voluntary association, again, which really that's what the DOD is. I mean, the military is all volunteer. It's a voluntary association, but it's a voluntary association that has all the guns. And if you're in this system, then, you're in the military. You're not under civilian rule. Now you're under the UCMJ again. And so if you're watching this because you're a veteran and haven't ever watched my videos, there's a lot of shit happening in America that ain't right. And it's like there is no civil government. People aren't using their full legal name. They're just pretending to hold these offices. It's a crime. I mean, it's a fraud. It's a treason against the United States. I pointed out in numerous videos. And now I'm talking more about, well, how are we going to combat the problem that there is? And one way may be for veterans who have been honorably discharged, because you're already in honor, you were honorably discharged, to take advantage of the benefits or the entitlements due veterans, and not chase the dollar individually, but work for the common good and take the benefit, the entitlement of $3,000 a month, and it's actually more than that, as I'm sure it will show itself to be. And be the eyes and the ears for the military government, which is in control. Because right now we are under the laws of armed conflict. So said Senator Lindsey Graham and Justice Kavanaugh during Justice Kavanaugh's hearings. That we are today, the United States is under the laws of armed conflict. We have been since 3 days after 9/11 when they passed some resolution or law, whatever it was, and that put us under the laws of armed conflict. Well, that means Field Manual 27-10 rules, and that's the laws of land warfare. And under those, we should be protected, civilians should be protected by peace treaties and. And anyways, I've done many videos on these subjects, so if you were to go to Rob Ryder, ROBBBRYDER, on YouTube and search by upload date or however they allow you to do it, my latest one was Lawmakers and Lawyers versus the Laws of Armed Conflict. But that one and veterans, where I talked about this the first time, about this idea that as a veteran, we have this available. It's a need-based entitlement, which means you need to say you need it, but you're entitled to it once you say you need it, to be classified unemployable, totally and permanently disabled, basically, and collect the pension instead. And then work for the common good. And so there's a number of these that go back for some time now. I've been talking a lot about the military, but the reason for this is if you were in the civilian world and you were to look at your paperwork, like your deed of trust or your warranty deed or your title insurance or your car paperwork or all these other things, they have Scrivener errors on them, which basically means they're not using your full legal name and they're not using their full legal name and they're really not using the legal name of the business that they say that they represent, and the court isn't using their full legal name and the judge isn't using his full legal name, and neither is the clerk and neither is the mayor and neither is anybody. using their full legal name. Well, then who are they? So if you went back and looked at sin of omission, classification 1H, you would see that the selective service system has classified everybody as a 1H, which means you're rated 1A, but you're unavailable. Well, if you're rated for 1A, but you're unavailable, then you must have deserted, right? So that would be a defect in your civil status in the United States. And some stupid bullshit like that is all it takes to, when the record shows that you're in error, until you change the record, well, the record shows you're in error. And we need to be changing the records. Hey, Grunt, I'm talking to you. Physical address, all these things have to really do for the last number of months now, all leading up to this last thing, which is what we're talking about now. And this can be a really long video that I break it into 3 parts because I want to show, I'm doing this first part to show people why we have to do it. The second part is how to do it, I believe, to claim your benefit. And the third part is, well, if you don't believe you can change records or make a difference in a record in the government, well, I did one in the military, and they agreed that by the law I was correct, and they changed the record. And so, it's good to appeal. But first you got to put it in, see what they say. You may not need to appeal. They may agree with you. If they don't agree with you, well, then you can appeal. So where are we now in this crazy-ass world? Let me just show you a few things that kind of all go together. So, again, this is for those that, maybe you're not looking to go get the entitlement. You believe you have a pension or you have a retirement or whatever, and if it is more than $3,000 a month, well, then you probably would keep it. But if it's less than $3,000 a month, well, you can get a pension. But what would you do once that happens? Well, here's part of the problem, right? The people that we believe are running the country aren't. And I really pointed it out quite well in this Lawmakers and Lawyers versus the Laws of Armed Conflict, in my opinion. But in Title II of the United States Code, that's the Congress, it says oath of speakers, members, and delegates. And so at the first session of Congress, after every general election of representatives, the oath of office shall be administered by any member of the House of Representatives to the Speaker, and by the Speaker to the members of the delegate present, and to the clerk previous to entering into any business, and to the members and the delegates who afterwards appear previous to their taking their seats. So you can't take your seat till you take the proper oath of office. The clerk of the House of Representatives of the 80th and each succeeding Congress shall cause the oath of office to be printed, furnishing 2 copies to each member and delegate who has taken the oath of office in accordance with law, which shall be subscribed in person by the member or delegate, who shall thereupon deliver them to the clerk, one to be filed with the records of the House of Representatives, and the other to be recorded in the Journal of the House and in the Congressional Record. Any such signed copies or certified copies thereof, or either of such records thereof, shall be admissible in evidence in any court of the United States, and shall be held conclusive proof of the fact that the signer duly took oath of office in accordance with law. Well, if it's going to be lawful, it needs to be legal, and to be legal, you got to use your legal name. And out of all that, what I just read, the thing that's of most interest today is the fact that it says that printed, furnishing 2 copies of members and delegates who shall take the oath of office in accordance with law shall be subscribed in the name of the member of the delegate, who shall thereupon deliver to the clerk, one to be filed in the records of the House of Representatives. That's actually the National Archives that has those. Well, I went and looked in the National Archives to see what was in there. And here's an example, an oath of office of somebody using a middle initial name and taking an oath that says, "So help me God." Well, that isn't the constitutional oath. This oath doesn't satisfy the 6th article of the Constitution because it has a religious test. And he didn't use his full legal name, but that's the oath of office that they have for him in the system. And they also have his certificate of election. I'm sure they did this on purpose to put one of each in there. Again, this is 1965. It isn't even, dated today, but it doesn't matter. It's still the same thing, right? You got a guy using the middle initial saying he's the governor. Well, who the hell is he? That isn't his identification. Thomas S. Foley isn't anybody's identification. And it says, that this is his certificate of election, in witness whereof I have hereunto set my hand and caused the seal of the state of Washington to be affixed. But I don't see any seal on it. All right, so what this is evidence that it wasn't done right. This is evidence of counterfeit certificates of public securities of the United States, which the creation of is a counterfeit. It's a fucking felony. And that's what these are. These are evidence of felonies, or they need to be corrected, right? There's your choice, correct it or it's a felony. You can either correct it or you can correct it and go to jail, but it will be corrected. And so this is the things that people in the Congress are putting into the records. And if you went to the National Archives page and you went down here to Center for Legislative Archives and read the little research in congressional records, blah, blah, you would see a research portal. And you could put in keyword like oath of office. And hit search. Right? Oath of offices for the 95th Congress. Well, we're at the 115th now, so where's that one? Well, how do you find it? Well, you contact the National Archives and ask them for a copy. So I've done that. I've, contacted them. I want a copy of the oaths of office and the certificates of election that have been filed in the National Archive for the 115th Congress. That's the one that's just finishing, right? We're going into the 116th to see what these people have in there. And if they've put in one with a middle initial name, I'm going to say, well, that's not their legal name. It's been defined. Right? Again, I didn't define it. The frickin' federal government did. In 6 CFR, Code of Federal Regulations, Part 37, it's the Real ID Act, where it says subparts A through E of this part apply to states and U.S. territories that choose to issue driver's licenses and identification cards that can be accepted by the federal agency for official purposes. Well, that's all I'm interested in. I want federal agency and official, right? That's what I'm looking for. I'm done with the frickin' fiction. Well, they define that name to be this thing called your full legal name, and it means an individual's first name, middle names, and last names or surname without use of initials or nicknames. So the minute you see somebody using an initial, like an attorney or a judge or a clerk or a member of Congress or Donald J. Trump, they ain't using their full legal name. And that's the one they have to. So to go a little further then, in Article 2 of the Constitution, for the President, it says, where is it now? Before entering into the execution of his office, he shall take the following oath or affirmation. I do solemnly swear or affirm that I will faithfully execute the office of President of the United States and will, to the best of my ability, preserve, protect, and defend the Constitution of the United States. Okay, but if you read that again, it doesn't use the word support. So although the President, by Article 2, has to take this oath does not satisfy the 6th article of the Constitution, which says that the senators, representatives before mentioned, and members of the several state legislatures, and all executive and judicial officers, both of the United States and the several states, shall be bound by oath or affirmation to support this Constitution. But no religious test will ever be required as qualification to any office or public trust in the United States. So again, there it is, no religious test. And yet, that's what Foley put in, so help me God. This oath that you see here is the oath that you would find in 5 United States Code 3331. And I guess it's okay to have, but it's not the oath spoken of in the 6th article. There's a different oath. And that oath is found in the very first law, the very first Congress passed after the ratification of the Constitution by George Washington, John Adams, and Frederick Augustus Motherlugberg, Speaker of the House of Representatives, where it said that being enacted by the Senate and representatives of the United States of America in Congress assembled, that the oath or affirmation required by the 6th article of the Constitution of the United States shall be administered in the following form, to wit, I, state your name, do solemnly swear or affirm that I will support the Constitution of the United States, period. That is the oath that needs to be done to support the Constitution. Okay, well, that isn't the oath that the president takes. And that isn't the oath that this representative took, right? Because he took one, so help me God. He's got a religious test. Doesn't cut the mustard. He didn't take, there's only one oath, right? This is the point. There's only one oath. The people that wrote the Constitution then wrote laws expanding what they meant by the Constitution. And the very first law they wrote is, this is the oath. This is the oath that satisfies the 6th article of the Constitution. I, do solemnly swear or affirm, in case there be, I will support the Constitution of the United States, period. That needs to be on its own piece of paper, sworn and subscribed to. Unless you can show me the law that changed it. But until then, that's what they said. And regardless, the 6th article says that there will be no religious test. No religious test shall ever be required. And you need to take one to support. And this oath the president takes doesn't support the Constitution. So he would have to take it also. Because, hey, he's an executive officer of the United States. He's the chief executive. Okay, so, that's the way she rolls. Now, give me just a second. I won't bore you with this as I... Okay, so again, all of that is to say that in Title II United States Code, oath of speakers, members, and delegates, just to prove that these people haven't done it properly, right? Whenever they get done, they're supposed to have filed it with the records of the House of Representatives. Well, that's the National Archives. The fact that the signer duly took the oath of office in accordance with law. Well, then the question is, what oath is that? Because it isn't this oath. Right? That's not the proper oath. The proper oath is, the one we had just looked at in 1 Stat 23. So, what did they do? So on January 3rd, 2017, right, that's the last time that a Congress sat. That would have been the 115th Congress. They had swearing in of members. The Speaker, according to the precedent, the chair will swear in members elect en masse. The members elect will rise and raise their right hands. The members elect rose, and the Speaker administered the oath of office to them as follows. And it says what oath they put in. This is the one that the guy signed, but this isn't the one that satisfies the 6th article of the Constitution. So it's not the one required by law because it has a frickin' religious test. It's built right into the oath. They say this is the oath, and it says, so help me God. So it's not the oath talked about one in the 6th article of the Constitution. Okay, that was on the 3rd. Then on the 27th, right, so 24 days later, in another hearing, they're getting together and they're doing their thing, and down here a few pages, they got to the speaker wanted to adjourn without objection. The House stands adjourned until noon on Monday next for morning hour debate. So they just adjourned the House. You know, they're going to act like they're filing all these oaths of offices into a record or something. But the House is adjourned. But if you look at all these different states now, so these are all the oaths of office for all the representatives for all the different states, and they're not using their full legal name. You got people using middle initials. You got people using nicknames, because I'm sure his name isn't Tom. It's probably Thomas, right? So forth and so on. All of these states, none of these people have taken a proper oath of office. President-elect Trump, and you need to do something about it. You need to disperse the belligerents, tell them to all go back, get their paperwork straightened out, and come back. Because until then, none of the states have seated any members of Congress in the United States, so they're warring with the Constitution. Right? This is what the Emancipation Proclamation was about, and the Pre-Emancipation Proclamation, and all the things happening around that time was the fact that the South didn't send anybody to Congress. Well, now nobody's sending anybody to Congress. We got the same problem. It's getting bigger. And there's the evidence. You know, now on a local level, like here's an oath of office for a guy that's pretending to be a prosecutor for Kalkaska County. But he says he's from the county of Kalkaska. And he didn't use his full legal name. And it wasn't subscribed or sworn before anybody using their full legal name. Right? Well, this guy here then, who isn't holding the office, he's filed a counterfeit certificate of a public security of the United States, which is a felony. That's what he's done. But he's claiming to have authority to initiate a misdemeanor complaint against somebody for, you know, numerous counts. So, but when we get to the page where, okay, well, who did this? Right, 7 counts, but there's no complaining witness, and it wasn't signed before anybody, right? It's not been subscribed. And I don't know if that's somebody's signature or not, but no warrant has been issued because the paperwork hasn't been done properly. There could not have been an arrest warrant based on this complaint. It's not complete. And yet the guys, you know, Dana's the one going to court about this, like it has been. And they did the same thing with a felony complaint. Right? So first they said Dana committed misdemeanors, and then they came to try to arrest him for the misdemeanors, and they said he committed a felony because, you know, he was wasn't participating. And they're trying to get him for possession of marijuana with an H, not with a J. Right? With an H, that is a class, is it class 1 narcotic? Whatever class it is. But with a J, it's nothing. You just tell them, I don't have any marijuana with an H. I only have it with a J. You got the wrong species. But another case where there's no complaining witness, no judge signed it, right? Yet there's supposed to have been arrest warrants issued for this stuff. Well, this is being done by people that are running around claiming authority using the middle initial name. Right? A judge claiming to be a judge using a middle initial name. And a prosecutor using a middle initial name. Well, I'd say that no, you're not who you say you are, that you have filed counterfeit certificates in the United States and you need to fix them and abide by the law, or you need to be arrested. Well, this is the shit that's going on in the real world. Right? Another thing that's going on is um, things to do with your property. So most people would say that this warranty deed is the thing that says that you own property, right? So if you believe you own a house, you probably have a warranty deed and it's been filed or recorded in some registered deeds office or records or whatever. But if you look at who it was done to, it's, Terry L. Wilson, comma, a single person. That isn't anybody's name. That's a legal fiction they made up to replace somebody's name. Right? Now, we could say that's a Scrivener error and tell them to fix it, but the point is they did it on purpose. Your name isn't on the deed to your property. And as it turns out, the warranty deed doesn't transfer property. It just says that the Dennis O'Neill has the right to transfer property. Let's look at those definitions real quick. I mean, anybody who has a house, you're going to want to go look at this because you all got this problem. Nobody owns their house at all. So a warranty deed is a type of deed where the grantor, seller, guarantees that he or she holds clear title to the piece of real estate and has the right to sell it to the grantee, period. That's all it's for. It just guarantees they do. It isn't that they have or that this document doesn't transfer title. It guarantees that the person who says he's going to do it can transfer title. The thing that transfers title is a thing called a quitclaim deed. And I'm not talking about the quitclaim deed that people do themselves after they have the property. No, this should have been done at the time of the transfer between the grantor and the grantee, with you being the grantee. A quitclaim deed is a legal instrument that is used to transfer interest in real property. They don't have one filed. They've not transferred the interest in real property. The entity transferring this interest is called the grantor, and when the quitclaim deed is properly completed and executed, it transfers any interest the grantor has in the property to the recipient, called the grantee. The owner, grantor, terminates, quits any right and claim in the property, thereby allowing the right and claim to transfer to the recipient grantee. But it doesn't warrant that the guy doing it can. So, see, you have to have both of these. You have to have the warrant that the guy has the authority to transfer the property, and then the quitclaim deed to show that he did transfer the property or the property hasn't transferred. And so if all you have in your records is a warranty deed, that one, we'll get to that one in a second, a warranty deed, and you don't have a quitclaim deed between Dennis O'Neill and Terry Lynn Wilson without any single person, right? That shit needs to come off there. I mean, I've done videos on this that I've showed earlier that you would look at that, this whole thing is wrong. All these are Scrivener errors. It doesn't have the right property ID. It doesn't have a right address. There's nothing right about the frickin' form. Well, it was drafted by an attorney, right? So these are his Scrivener errors. So they don't seem to want to fix them. And it wasn't just done on the warranty deed, right? They did the same thing on, call it the deed of trust or mortgage or whatever it is that you believe, or they are saying shows that you borrowed money, like a purchase money mortgage. Right? Who's the borrower? Terry L. Wilson, comma, an unmarried woman. Again, that's not your full legal name. In legal matters, you got to use your legal name. If you're not going to use your legal name, and you're going to do it under an assumed name, which Terry L. Wilson, comma, an unmarried woman is, that could be the name of a legal fiction. Well, then you have to file a DBA. But if you're doing it under your full legal name, Terry Lynn Wilson, without an unmarried woman, just borrow Terry Lynn Wilson, well, then Terry Lynn Wilson would have been making a contract. So there is no contract because that isn't your full legal name if you're the borrower, or supposed to be, and they're not using the proper information for the lender either, which I've gotten into other videos. I really don't have time right now. But you get my point. This is what they're using when they take people to court to take their houses. So here's a letter, written by an attorney, Gray and Associates going into this case that has to do with Terry Lynn Wilson et al. They don't call her Terry Lynn Wilson, right? So Terry Lynn Wilson, the real person, don't have a damn thing to do with this foreclosure because her name isn't on the paperwork. Although that's what we were trying to get them to recognize and blah, 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 blah. So, here's a legal document being put in by an attorney into a court case. And how does this judge, or how does this attorney do his paper? William N. Fossag. He's not using his full legal name. That isn't the name that would be on any roll of attorney or any other thing. It's not the name on his driver's license. It's not the name on on anything that would identify him for official purposes. Yet that's the name that he's using. So he is using a fictitious name and simulating a legal process, which is another felony against the United States. And he's learned that the law. I mean, he should know better. He does know better. It's part of a scheme. Let's see, what name did they use for the judge? Right, Barbara W. McCrory. That's not her full legal name. Now, if this is some kind of military tribunal, because there is a gold fringe flag in the courtroom, and that would signify that the federal law applies here, and that's an Army flag that would signify that they've claimed the territory. And she's, a judge working for the military, got a contract for the job. Well, she's not doing a very good job. She needs to be reported to the military. Which is all part of the reason for claiming the entitlement, getting the ID card, filing a complaint through the military channels, because there's no place to take it to here in the civil world because we're under military rule. And okay, I'm going to leave it at that because this is just one part of a 3-part video, which is going to be pretty long when it's all said and done. But I'll put the different times that they go to in the thing. I'm just trying to show to master chiefs and sergeant majors and people that have 30 years in the military and whatever. Look, I'm not your enemy, and I'm not trying to get something I'm not entitled to. I'm going to get it and go use the powers that go with it to try to change the United States, because right now there is no government. Right? The government has been vacated at the state level and at the national level, and all there are then, because all the powers that didn't go to the national government go to the states or to the people. Well, if there's nobody in the state, then the people have claimed them, all of these powers, and they've claimed them under as a voluntary association that then gets incorporated, and being properly incorporated and having a chaplain gives them a tie between the church and the state. And really, that's what you need to do in anything, because, well, the church is the state. There is no separation of church and state. That's some fool's idea. It's never going to happen. Long live the Queen. So in the United States then, because the United States of America is a kingdom of King George III. He said so in the Treaty of Peace in 1783. Right? That's what's here. And he's still claiming his entitlements. Well, I served in the Army of the United States of America, so he says I get these things. It's a crazy world we live in. I'm not going to try to understand it all. Right now, I'm just going to go claim my entitlement. And then try to file a complaint against people who are claiming to have authority under the United States who really don't have it. Okay, y'all have a great day, and Part B will be up next, Part 2, and then Part 3 soon after. Y'all have a great day. We'll see ya. Okay, again, unemployability isn't a 4-letter word. On Sunday, December 2nd, 2018. This will be Part 2 of this video, where I'm going to concentrate on the forms and the substance for having an unemployability claim. This is my interpretation by what I've read, by looking at the VA forms necessary for individual unemployability claim and the laws governing the entitlement. And those laws are basically, if we're going to call them that, it's in 38 CFR, which is the Code of Federal Regulations under the Department of Veterans Affairs, right? So Title 38 of the Code of Federal Regulations. And the M21-1MR Veterans Disability Manual that they use at the Veterans Administration. Both of which, one way or the other, all this information can be found online. And for myself personally, why these things are important is because of my background. I used to work at this nuclear power plant, Davis-Besse Nuclear Power Station, and nuclear power plants are run by the federal government and or overseen by the federal government, right? They have lots of procedures. They have lots of forms. They got lots of things, and they expect you to do it right. And so, to me, this is no different than, well, I'm going to look at the VA stuff and see what it says is supposed to have been done or what can be done, and see what I can do with it. So without any further ado, let's go here first. So let's just really quick lay out the forms that you might need. So if you never put in a claim at all, then you need to put in this. It's a Form 21-526-EZ, right? So VA Form 21-526-EZ. And the other one that goes with this, for unemployability, so now let's say you have already put in some kind of claim in the past and gotten some kind of compensation, well then this form, which is VA Form 21-8940, is the form that you use to have your increased compensation based on unemployability. Not on the percentage of your disability, on the fact that you're saying you're unemployable. Those are the two main ones. And then they have, well, this is a disclosure form you might have to have if you're trying to get records from the private into the VA for them to look at. I don't know that it's necessary, but this one may be a statement in support of claim, because one of the things they talk about doing is supplying evidence. So evidence to start with would be like your DD-214 to prove that you are a veteran. But then you can put in a supportive claim, right? So you can write your own support claim. As you can see, I did. And this other one, request for employment information in connection with claim for disability benefits, which is something that would go to your previous employer. They have a time frame that they're looking to have, years back and so forth, to make these determinations on if you are substantially gainfully employed or not. And if you're not, well, then you can have the disability. What else do we have? Handling claims. So those are forms. Here's one of the laws, handling claims under 38 U.S.C. 5103, which is, this is like the VA's book, how they're going to handle their business, their policy. And part of this is that they have to, under this particular section of the United States Code, they have to send you a letter, notice to claimant of required information and evidence. So this is, after you've sent in these initial things, it would say required information and evidence. Upon receipt of a complete or substantially complete application, and of course they have a definition for that, The Secretary shall notify the claimant and the claimant's representative, if any, of any information and any medical or lay evidence not previously provided to the Secretary that is necessary to substantiate the claim. As part of this notice, the Secretary shall indicate which portions of the information and evidence, if any, is to be provided by the claimant, and which portion, if any, the Secretary, in accordance with 5103A of this title and any other applicable provisions of law which will attempt to obtain on behalf of the claimant. So the VA has a duty to help you gather the information you need to substantiate your claim. And when you send the claim in and they look at it, they say, well, based on what you're asking for and what you've given us, we would still need A, B, and C. A may be something you can give them, and B and C is something they can get. And that's what this letter is going to say, is who has to get what to finish the claim. And so this week, I'm going to try to find out where I stand in this process, because I have submitted mine, and find out, okay, well, are they sending me a letter or not? Do they have everything? Don't they have everything? Where are we at? But the idea of having a 5103 letter is the thing that shows, that they are working on your claim and what they say they still need to substantiate your claim. If they don't need anything, well, that means they agree with you. Right? Because it's to substantiate your claim. The Secretary shall notify the claimant and claimant's representative, if any, of any information and any medical or lay evidence not previously provided to the Secretary that is necessary to substantiate the claim. And you're putting in a claim for unemployability. Well, that's what I'm doing. Right? It's not on the percentage of your disability. It's on the fact that you're disabled at some point and say, I can't do this work anymore. Yeah, maybe I can walk around and stuff, but I can't work in the system anymore. And they base that on the fact that, you're not making $36,000 a year or whatever it is, because that's what they pay for disability. Anyways, I'm going to leave it up to them to decide. I'm not going to, if they want to give it to me, I'll take it. Again, because not only do you get that, well, you're going to get an ID card from the military with a DOD ID number. You can get back on any base you want to and so forth. And so technically, you just put yourself into a voluntary association called the Department of Defense. And now they're going to give you an ID card, and they're almost like their own government. Well, they are their own government. They're the government that has the guns. And so it would be just like you being in the military before, and if there was a complaint about some kind of crime and you needed to report it, well, there's a process to do that. And there's all sorts of crimes happening because nobody's enforcing the laws of the United States, and that makes it the military's duty, but the military isn't doing it today domestically because nobody's bringing it to their attention. So, hey, that's part of what the videos are for. It's part of what getting the ID is for. It's what getting the benefits and everything is for. It's to put myself back in the military, and now I go tell them to do it. I can go to the MP station. I go on post. And if you point out the truth, man, there's not much they can do except, well, you're correct. I know they don't do that here in the civilian world. That's the problem. But they don't. They do things a bit differently in the military. Okay, so give me a second to get my ducks in a row. What I'm going to show first. Hang on here. As a matter of fact, part 3 of this video will be me showing that I filed an application to correct a record in the military, and they did correct it because I pointed out the law that it was right. And so they had a hearing, and they corrected the record. So things can be done in the military by pointing the law out to the right people and having them do something about it. So let's get there first. What does the law say? Well, in Title 38, Code of Federal Regulations, so 38 CFR, right, at 3.321, General Rating Considerations, they got a schedule from 1945 that they're basing all this on for disability compensation. But then they have this thing called extra scheduler ratings in unusual cases. Disability compensation ratings shall be based, as far as practicable, upon the average impairments of earning capacity, right? Upon average impairment of earning capacity, not physical capacity, earning capacity, with the additional proviso that the Secretary shall from time to time readjust this schedule of ratings in accordance with experience to accord justice to the exceptional case where the scheduling evaluation is inadequate to rate a single service-connected disability. The Director of Compensation or his or her delegate is authorized to approve on the basic criteria set forth in this paragraph. B, an extra scheduler evaluation can measure it with the average impairment of the earning capacity due exclusively to the disability. The governing norm of such exceptional case is the finding by the Director of Compensation Services or delegate that the application of the regular scheduler standards is impractical because the disability is so exceptional or unusual due to such related factors as marked interference with employment or frequent periods of hospitalization. Blah, 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 blah. So, hey, they have a way to do it by the book, and then they have a way to do it by, by the heart. Pension. Where the evidence of record establishes that an applicant for pension who is basically eligible, well, to be basically eligible for a pension in the military, you have to have served 2 years if you enlisted after 1980. Fails to meet the disability requirements based on the percentage standards of the rating schedule, but is found to be unemployable by reason of his or her disabilities, age, occupational background, and other factors, the following are authorized to approve on an extra scheduler basis permanent and total disability rating for pension purposes. Right? A permanent and total disability rating for pension purposes. The Veteran Service Center Manager and Pension Management Center Manager, or where regular schedule standards are met, as a date rating, the ratings board. And so if you are truly disabled to a high enough level, they'll give it to you automatically, this permanent and total disability rating of 100%. But if you're not physically disabled by their estimations to that level, you can ask for it separately and say, well, because of my disability, I can't maintain substantially gainful employment. Right? And, working at McDonald's isn't what they consider substantially gainful employment. That's like being unemployed. Title 38, CFR 416, total disability rating for compensation based on unemployability of the individual. So what is it based on? On unemployability, not on disability, on unemployability. That's how they're going to give you your rating. Without reading all these things, it says in B, it is the established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow substantially gainful occupation by reason of service-connected disabilities shall be rated totally disabled. Therefore, rating boards should submit to the Director of Compensation Service for extra scheduler consideration all cases of veterans who are unemployable by reason of service-connected disabilities, but who fail to meet the percentage standards. Total disability rating for persons based on unemployability and age of the individual. See? So it's not just how unemployable you are, and then they bring in your age and all these other factors. Claims of all veterans who fail to meet percentage standards but who meet the basic entitlement criteria and are unemployable will be referred to the rating board, to the Veterans Service Center Manager or Pension Management Center Manager under 3.321B2. Hey, we read that earlier. Right? That's where this came from. And that's where it talks about having a pension. Right? If you can get an extra scheduler rating, well, they'll give it to you. And then they talk about if you have any of these chronic diseases, anemia, arthritis, bronchitis, on and on and on. You can say that it happened in the military, right? It doesn't matter where it started at. If you had it, you can claim it. And I'm going to let them decide why that is. That's just what they said. I'm not looking for a reason to make it not work. I'm going to say, okay, well, that's good enough for me. If you had any of these things, you could say, well, there's my percentage or my disability. But, you can use like ringing in your ears as a disability, or diminished hearing. I worked around a lot of really noisy equipment. I know my hearing's not nearly as good. Right? So, anyways, we'll get into that stuff more in a bit, but this is what the law says, right? I didn't say it. I'm reading their law. So I'm going to say, well, it's the established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow substantially gainful occupation shall, by reason of service-connected disabilities, shall be rated totally disabled. Shall. It's like in my case, I haven't filed a 1040 since 2002. As far as I'm concerned, I've not been substantially gainfully employed since 2002, so I want back pay. I didn't know I had this benefit before. And this, by the way, this isn't a benefit, this is an entitlement. But it's a needs-based entitlement, so you have to come ask for it. Right? It's not a benefit. You are entitled to this. That's why they're making it really easy. If you come ask for it, they're going to give it to you. Save that one. Okay, what else do we have? Determining disability, unemployability, and marginal employment. This is out of that manual, M21M1-MR, Part V, Subpart 2, Chapter 1, Section B. I don't know what to tell you. I'm not the numbering, the person that made up the numbering system, but that's what they have. The definition of substantially gainful employment. This topic contains information determining unemployability. That's all I care about is, well, how are they going to determine unemployability? If I can make it work for me, well, I'll take the benefit. Unemployment is established for pension purposes when the evidence shows an inability to secure and retain substantially gainful employment by reason of disability, as well as related factors. Substantially gainful employment is employment that is ordinarily followed by the non-disabled to earn their livelihood. Well, hang on. You're not non-disabled. You are disabled. So you can't do whatever non-disabled could do. It is employment that is ordinarily followed by the non-disabled to earn their livelihood with earnings common to the particular occupation in the community where the veteran resides. Now, there's a chance that what you've learned in the military or whatever there's no use for in your neighborhood. Right? So you shouldn't have to move chasing jobs. You say, well, I want to live here. I'll take my pension. And if you can imagine, when you take these pensions and quit looking like you're getting something for free, and say they have all this money stuffed in all these accounts, it's all book entry money, it hasn't been made into legal tender. By you claiming it, and now it is converted to legal tender, from book entry to legal tender, it can be spent for all debts, public and private. And you're going to take it and put it into the real economy that's starved for money. That's why nobody makes any money. Nobody has any. It's all been taken out, put into, the hands of a few. But in their doing that, they had to put some into the hands of the people, and it's in these bags, in the CAFR accounts, and we need to cut a hole in them and start draining some of the bags. General information. In many instances, a veteran's unsupported statement will be enough evidence to establish unemployability if it is consistent with other facts of the case, such as a good work record. In other words, if you are honorably discharged, right, your unsupported statement that you're unemployable is enough for the military to say, we agree. That's why doing that statement form is, that's why I did it. We'll find out what it does. Both the degree of disability and the veteran's age are determinative factors as to unemployability. Consider age, education, occupational background, and other related factors when making a decision of unemployability in pension claims. And working for $10 an hour isn't being employed. It needs to be substantially gainful employment. If basic eligibility is present, do not hesitate to apply. 38 CFR 3.321. Hey, what does that mean? It means, well, they said that they're going to give it to you anyways. Right? If you don't meet the percentages, go to 38 CFR 3.321 and do whatever B2 says, which means get the extra scheduler endorsement. Exercise restraint in discounting eligibility to pension benefits for veterans already on the rolls merely because they have recently regained employment. You can just say, I don't want to do this anymore. It hurts too much. Factors to consider when determining unemployability. Now, that doesn't mean you just go home and sit, right? But if you didn't have to work at some freaking job, what would you do with your free time to help your country and your neighbor and so forth, right? You could be the world-class volunteers. Factors to consider when determining unemployability. A veteran whose sole employment consists of performing household duties may qualify as unemployable if the veteran is no longer able to perform principal household duties without substantial help. And they'll take your unsupported statement to be that you're unemployable. Inability to compete in the labor market because of age or disability is a valid basis for finding of unemployability, even though the veteran did not actually become unemployed because of a particular disability. That is the point. Inability to compete in the labor market because of age or disability is a valid basis for finding of unemployability, even though the veteran did not actually become unemployed because of a particular disability. Well, I haven't mentioned it yet. These benefits and so forth, anybody over 65 that served in the military is supposed to get a pension. And then there's a survivor's pension that goes with that, and I'm not going to really have time to cover it in this video, but even if you're the spouse of a deceased veteran or dependent child of a deceased veteran, these benefits are available for you. It's a matter of filling out the forms and asking for it. And I'm not an expert on any of this. I had never really looked at it myself until here in the last month or so, but if you look, I do a lot of videos on things that I've read, and I'm just doing another video on things that I've read, and I'm going to fill the forms out and put it in and see what happens. I think that's enough. This one, that was the basis for that one. Determining unemployability or marginal employment. I mean, it's really no secret. They're going to use some dollar amount. Say if you don't make over this amount, you can have the total unemployment. If you do, well, you're substantially employed and you can't have it. Compensation based on individual employability, unemployability versus unemployed and unemployable. Definition of substantially gainful employment. IU is also referred to as total disability based on individual unemployability, which is TDIU. So they're hiding all these things behind these names of things, right? But they're going to give you a particular rating. And the thing about this rating is, the way it's been written into the law, it can't be reduced once it's been given to you. You are totally disabled. The term unemployability is synonymous with the terms unemployable and unemployable for the purpose of determining entitlement. Unemployed and unemployable for the purpose of determining entitlement to increased compensation. A veteran may be unemployed or unemployable for a variety of reasons. determination as to entitlement, right? Entitlement to a total evaluation based on employability is appropriate only when the veteran's unemployability is a result of SC disabilities, service-connected disabilities. Well, how are they going to know that unless you tell them that's what it's from? So put the form in. A decision concerning entitlement for an IU evaluation is based on a review of all available evidence, which should be sufficient to evaluate both the veteran's current degree of disability and employment status. For the VA 218940, which is the veteran's application for increased compensation based on employability to the veteran if a request for IU is expressly raised by the veteran or reasonably raised by the evidence of the record. Right? So if you already have filed paperwork into the VA and you know the system, you need to tell them you want to put in the form 218940 and claim unemployability, if that's what your problem is. We got a lot of veterans that are living homeless right now that they shouldn't be. They should have this pension, complete health care, an ID card, access to all the bases, non-taxed. In fact, my brother-in-law Brian has this now, and he bought a house, and he doesn't pay any ad valorem taxes. Where his taxes were going to be like $2,000 a year, and they're only $400 because he's not paying any ad valorem taxes. And when he went to get a hunting license or a fishing license, he lives in Florida. He came here to Michigan for $1. He got all the licenses that you can get to hunt and fish in Michigan for $1. Pretty good deals. Right? And he did the same thing in Florida. That's the point. He's got the same thing in Florida. It's, wherever you go, for $1, you can have all their licenses. A claim for IU may consist of any written communication indicating the veteran is unable to work because of SC disability. So fill the form out and send it in. That's all it takes, right? That's the claim. A claim for individual unemployability may consist of any written communication indicating a veteran is unable to work because of service-connected disabilities, right? Expressly raised by the veteran, and put it on the form 218940. Request each employer for whom the veteran worked during the 12-month period prior to the date the veteran last worked complete and return the VA 2192 request for employment information. This is one of those forms you may have to do if you're working at McDonald's or whatever it is. If you're not making $36,000 a year, well, you have to send these people your form. But this is the thing, right? So if you put it in and it's substantially complete, then you're going to get this letter back that says the things that you need to do for the VA to acknowledge your claim or substantiate your claim. Self-employment development to produce the evidence necessary to establish the degree of which the SC disability has impaired the veteran's ability to engage in self-employment must generally be more extensive than development in cases which the veteran worked for others. Okay. I'm going to let everybody else figure that out. A tightly held corporation or closely held corporation is usually a family corporation. A corporation bearing the veteran's name is usually indicative of a tightly held corporation. Because if you have your own corporation, well, now you can still get your benefit and have this corporation. Now, the corporation they're talking about, as far as I'm concerned, is you getting an EIN number in your full legal name, mine's Robert Allen Ritlewski, as a sole proprietor. What you can do, and I've done, I got an EIN number, and it says that Robert Allen Ritlewski is the name of my business, and its owner is Robert Allen Ritlewski. Well, that's me doing business in my name. Then I don't need a DBA because I'm not doing business in an assumed name. I'm doing business in my name. And then if you had any tax things to pay or whatever it is, you can run yourself as a business and fill out a Schedule C for 41, or what is it? IRS form that you fill out? I haven't filled out an IRS form in so long. But whatever the number is, they have a Schedule C with the same thing. Jeepers, man. What's the form they send you for your taxes? Well, okay, they send you that form and it's got your name and a middle initial. You need to say, hey, this isn't me. I don't have a middle initial. Don't know who you're talking about. I got a full legal name. If I don't have Robert Allen Ritlewski, you ain't talking to me. Okay, so that's that one. Again, I'm just trying to show, to those that would say, well, how is it that you say you can have these things, that I'm not the one saying it. The frickin' VA is saying it. I'm just trying to take advantage of it and show it to everybody else that could have advantage of it if they read it the same as I do. So not only do you have physical disorders, you have mental disorders, right? That can be considered. And so, this is where you would find PTSD, being here someplace. But they also have this one, chronic adjustment disorder. There it is. It's got its own number. Well, what is chronic adjustment disorder? It just means you can't adjust to the society you found yourself coming back into. Because now understand something, people in the military. If you were in the military, you ain't the same person who came out of basic training or the military as what went in. They've definitely played with your mind. I'm not saying it was necessarily bad or wasn't even for your benefit, but the fact is they did. Right? So the fact that you can't adjust to the world is their fault because they, tweaked your brain in basic training. So I think that was about all of those. Now I had one thing over here. Make sure we talked about these things. So, okay, this is the 38 United States Code 5103 that says, upon receipt of the application, the Secretary shall notify the claimant and the claimant's representative of any information and any medical or lay evidence not previously provided, which so means they don't have it yet, to the Secretary that is necessary to substantiate the claim. Okay, so we'll have them tell us what it is they still need. But if they don't tell you they need anything and you submitted a substantially complete request, then, they should pay it. I know they will pay it. I mean, they paid my brother-in-law's. Okay, now somebody put this manual together because this M21-1MR is weirdly combined, right? Somebody did put it together. And they say this full 395-page manual in this format was downloaded from disabledveterans.org. Right? And so it's not numbered the same as it would be if you were looking at the VA form itself or the VA manual, but it's got the sections in it. There's just a couple I want to look at. This has to do with the duties to assist, right? That they have these duties to assist. This section contains information about duty to assist, including claimants, relevant federal records, non-federal records, requests for VA examinations, circumstances where VA will refrain from discontinuance, providing assistance, and contact information for questions. VA's duty to assist includes developing all relevant records in the custody of the federal department or agency, including VA medical records, service medical records, Social Security records, evidence from other federal agencies. All right, they got to help you put your package together. That's their duty. They talk about accrued benefits. I'm still trying to figure out if that's different than pension or what, because I'd say accrued benefits could be, in the military, everybody had a life insurance policy on which you were really the beneficiary, and then you choose somebody to get the benefit. But, you made yourself the beneficiary. You're the beneficiary of the policy. They talk about these being, some kind of term insurance, whatever. But once that stuff is started, right, it has a value forever. If that, is then at that point put into an account and just draws interest, well, it still has a value. So handling claims under 38 U.S.C. 5103, this has to do with that letter they're supposed to send you. Handling the VA 21, 41, 42, authorization for release of information, blah, 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 benefits claim. Faxed or photocopied signature is acceptable, right? They're not asking for a lot of proof, just a little. Handling claims not previously denied, the section 5103 notice referred to in this block, and throughout the manual refers to the section of Title 38 United States Code that directs VA to notify claimants of information of evidence required to substantiate their individual claims. They need to tell you what you still need to give them for them to substantiate your claim, or for them to acknowledge your claim's been substantiated. Now, part of this letter is with this notice is supposed to include a VCAA notice response form. So they're going to send you a notice, and in the notice will be this VCAA notice response form, on which you can tell them, notify the VA that he or she has no further information or evidence to submit, and request a decision on his or her claim without further delay. Don't wait on nothing. Go ahead and do it. Tell me where we are. Because you can always appeal. A claim for an increased evaluation of service-connected disability based on a statement from the claimant that his disability has worsened constitutes a substantially complete application. Right? So a claim for increased evaluation of a service-connected disability based on a statement of the claimant that the disability has worsened constitutes a substantially complete application. That would be like you putting in one of these sworn statements, or just a statement. It's not even a sworn statement. When veterans request or assert entitlement to a specific evaluation, including a total evaluation based on individual employability, that would be IU, or a specific effective date, the Section 5103 notice must provide the criteria that must be met to substantiate their claim. The following statements constitute claims for specific evaluation. I believe my knee should be rated at 40%, right? So that would be for a disability percentage, but you could also say my PTSD makes me totally disabled. You could tell them your knee makes you totally disabled. You don't need to say rated at 40%. No, it makes me totally disabled. I'm unemployable. Other types of specific claims, such a claim for total evaluation based on IU, must use the appropriate letter and attached forms and so forth. So I hope you can see, at least for me, it was like, well, they make it really sound like they want you to ask for this, so I'm going to go ahead and do it. Right? And that's just what I'll do. I'll just ask for it. Now, I had never filled this form out before, the 21-526EZ, which is that's like the first form to do if you're looking to get any kind of compensation for a disability. Right, so disability service connection and individual unemployability. Well, check. That's what I wanted for. This notice informs you of the evidence necessary to decide your claim. After you submit your claim on the attached application, you will not receive an initial letter regarding your claim. You do not need to submit another application. So, after talking about the 5103 notice and what it means, what they did is they combined that notice into this form and made this thing called the EZ form when it used to just be a 526 form. And so this form and the notice will tell you what you need to give them, for them to substantiate your claim. Just like it was combined together. If you want to do it electronically, well, you can go to e-benefits, right? You can also support uploading supporting evidence, which you need to send a DD-214 for sure. And if you're going to send a claim form, a statement, that also. If you were going to send medical form or medical stuff from outside the VA, well, then you'd have to get it. But right, that's up to you to decide what that is. But for sure, your DD-214 if you've never filed before. And if you're filing for unemployability, well, then the unemployability form and also the statement form if you're going to do a statement. Right? If you wish to contact an accredited Veterans Service Officer, a VSO, to assist you with your application, you can. I'm not opposed to somebody doing that, but I'm not depending on them to tell me if I can or not. I'm going to go ahead and put it in. I can do it myself. I don't need somebody to do it for me. So, somebody went down after I did my other video on this and talked to these people, and, they kind of roll their eyes a bit, and they don't seem like they want to help or that they understand it. Because they haven't read these books. Look, I don't care what countertrol you're talking to. They haven't read their law. They're just doing whatever they were told to do since the day they got there. I've always done it this way. Now, it doesn't mean they can't go read their book and do what it says. But if you try that in the civilian world and bring their book into the clerk or whatever, they'll say, well, we have to get an answer from our attorney. Right? We're here. You're going to give it to these people and say, well, this is what the law says. So now you're going to have to show me why you're not doing it. Submitting a claim, how things you need to do. Well, you must submit all relevant private treatment records if they exist. Identify any treatment records available at a federal facility. Identify the location, sufficient information to obtain National Guard, Reserve personnel service treatment records if applicable. Now, in my own case, I spent 8 years in the military. I have no medical records whatsoever in the military. All right, I got dinged up a bit, but I never went to the doctor for it. There's no record of it. But it was more by the grace of God than anything else. So, I'm like the case, well, if they take mine, they'll take anybody's. All right, send all this information along with your claim. All right, these are things you must do because you're trying to get a FDC, fully developed claim, in, so you want to be able to check the box on the form and give them the things they do and then have them do what they're supposed to because it was done, expediently because you've already developed a claim. You gave them what they wanted. If claiming, right, so this is the special circumstances. If claiming individual employability, submit a completed VA Form 218940 with this form. Okay, if you're claiming PTSD, well, claim that one. If you're claiming dependence, well, put that form in. Whatever you're claiming, here's the forms you need to give them to provide them the evidence they need from you for them to process your claim. Now, they may need your records, and they're going to go get those from the military, but they don't need anything else from you. VA will retrieve records from the VA facility. Well, where to send your information and evidence. So I did mine, and I sent it to this fax number. Right, and as you'll see, I did it on the 16th, and I checked on the 26th, and they had it. And they had said, oh, it looks like a letter's been sent to you 2 days ago. Because I was talking to somebody on the phone. But they didn't say what letter it was, and I didn't realize about the letter we're talking about now. But it said that, what they needed from me was my employment record. And I said, well, that's on my paperwork I already gave you. It shows I haven't worked since 2002. I said, that company isn't even there anymore. Oh, they're not there anymore. No, they don't exist. Oh, okay. So she started to, like she was answering these questions that was on the letter that was coming to me in the computer, and that's already been taken care of. I haven't got the letter yet, but when I do, I'll see what it has to say. So if you are claiming your service-connected disability prevents you from getting or keeping substantial employment, see the evidence table entitled Individual Unemployability. So, where's the evidence tables? Here they are. Service connection. Increased disability compensation. If VA previously granted service connection to your disability and you are seeking increased evaluation of your service disability, we need medical and lay evidence to show worsening and increased serviceability, severity, and the effect that worsening or increasing has on the ability to work. Well, what's the effect? It's made it so I can't work. Evidence table, compensation, temporary total disability. Here we go. So this is the thing for individual employability as far as the evidence. In order to support a claim for total disability rating based on individual unemployability, the evidence must show that your service connection disability or disabilities are sufficient without regard to other factors to prevent you from performing and keeping substantially gainful employment. In order to support a claim for an extra scheduler evaluation based on exceptional circumstances, which that's what I'm doing. I mean, I know that I don't have the physical disabilities to get it by the percentages, but in order to support a claim for an extra scheduler evaluation based on exceptional circumstances, the evidence must show that your service-connected disabilities or disabilities present such exceptional and unusual disability picture due to such factors as marked interference with employment, I haven't worked since 2002, or frequent periods of hospitalization, that application for regular scheduler standards is impractical. Okay, well, I agree, it's impractical. Goes on and on and on, all these things about the evidence, right? So for everybody would just have to take their time and look at it themselves or put it in and see what they come back with. But eventually in this thing, because it's a 12-page document, the last 4 pages have to do with the actual form they're going to fill out. And so just quickly, that's what I did. I said, well, mine's fully developed. Myself, I don't say I have a middle initial or a middle name even. I have a given name. It's Robert Allen. And because there was enough room in the box for me to put Robert Allen, I did. If that box hadn't been big enough for Robert Allen, I probably would have put an A in the middle initial box. But I choose not to do that when I can, because I don't have a middle name. I have a given name. My name's Robert Allen. You want to talk to me officially, you got to use the name Robert Allen, not Robert A. But in the military, you can serve under a fictitious name. Hey, go figure. Social Security number, as it turns out, that's the same as your VA file number. Have you ever filed a claim before? Nope. I don't believe I did. Date of birth, sex, that's standard stuff. Address. Your unit number, if you live in a single-family house, is the last 2 digits of your house number. It's called the delivery point. I've done videos on that. I'm not going to explain it all real well, and I don't even care if you put it in. I did, because I know that 55 is my unit number. No change of address. I should have checked this box here. Are you currently disabled or homeless? No. But are you currently at risk of becoming homeless? Yes. Right? Point of contact. And then finally you get to what's the claim. So I just did it kind of like this said right here. It wasn't asking for anything specific, from a doctor, just, well, what's going on? So hearing loss, noise. Those duties of my MOS, 52 Echo, July 1986. Limited neck motion arthritis, injury on obstacle course during basic training, March 1979. Eyesight. Eyesight's deteriorated during service. I don't know, let's go check my record, see if it was the same when I went in and when I came out, if that's what they care about. I don't know. Ringing in ears. That would be noise, right? Duties of MOS 52 Echo. Because I consider, hearing loss different than ringing in ears. Chronic adjustment disorder. 8 years active duty service, United States Army. Duty, honor, country, prohibit my working for enemies of the United States. Which I say is what's running, what is acting like they're running the country. And you would have to have watched the first section of this video. If you did, then you understand that none of these people that are pretending to hold office have filed an oath of office in their full legal name, except the military. And therefore, they're not holding an office. What they did is they created a counterfeit certificate of a public security of the United States. And that's a felony against the United States, and they, either they need to correct it or they need to be arrested. Wrist and thumb weakness, limited motion, slips and falls, dismounting 2.5-ton truck. Back and hip stiffness, arthritis, tumbled down a mountain. Well, I was skiing in France, January 1981. Frequent lung infections, tear gas and other chemical irritants. Exposure to chemicals while on active duty. I don't know, I didn't have the problem before I went in, and, I have it now. I'm going to say it happened in the military. But that's what they want, a list of your current disabilities. Not asking for any doctor's information, just what are they? And then enter the disability treated and name location of treatment facility. Well, I didn't go to any place for any of these. Right? So again, I don't have any doctor's information. Right? I'm doing it all on my own, saying, well, I said it happened. I'm going to E6, 8 years active duty service. Right? I expect you to believe me. Individual unemployability, and it tells you what forms to use. So again, it's this form that we're looking at, and then another one, which is the, or actually, it's this form is the 526 easy, and then they're saying you need to send these other two forms. One being for the increased disability because of unemployability, and the other being your employment history. Right? Did you use any other names in the service? Well, yeah, I used Robert A. Rutluski and Rutluski, Robert Allen. And, place off of my DD-214, my last separation place. Are you currently serving? No. 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 Right? This has to do with your getting retirement and so forth. So this is all different for other people. Even if you're getting retirement or whatever, you should still put it in to see what the difference is, right? Because somehow you'll be able to group the two together and come out with a larger total than you have now. This is all about your banking information, account number, so forth. Because if they agree with you, well, all they're going to do is start putting money in your account. All right, so they want to have all that information up front. Thank you very much. So this is the form 526EZ that you have to do. Now the one that goes with it for unemployability is this one, the 8940, VBA 218940, Veterans Application for Increased Compensation Based on Unemployability. Hey, name again, same information as before, addresses, email. What are you claiming? Chronic adjustment disorders, arthritis, hearing loss, ringing in ears, frequent lung infections. Got any information? Hospital? Nope, I ain't got nothing. Nope, nothing. Employment statement. All right, the last time I worked was 1/1/2002, officially. All right, at the time, $100,000 a year for 1999. Owner, Heidelberg Printing Press, repair, refurbishment, installation, shop. Michigan Press Repair, but they're not there anymore. So I can't give them anything. So what am I making now? Zero. Did you leave your last job, self-employment, because of your disability? Yes. Did you expect to receive disability retirement benefits? Yes. Did you expect to receive workers' compensation? No. Right? Because I'm saying, well, I expected to receive disability retirement compensation from the military. That's why I'm filling out the damn form. I may be able to get workers' comp too. Um, is this the form? Where's the form where they talk about? Here it is. Social Security benefits. Individuals who have a disability and meet medical criteria may qualify for Social Security of supplemental Social Security disability benefits. If you would like more information about Social Security benefits, contact your nearest Social Security Administration office. You can locate the address, so forth and so on. But what you want to have is your total disability first, and then go there. Because I think you can get SSI also. Okay, schooling. MOS 52 Echo, Prime Power Production Specialist, Electricity Prediction. The things I did prior to 2002. What have I done since then? Well, I've been taught by the Holy Ghost to research how to identify domestic terrorists, false accusers, foreign and domestic enemies of the United States, by their deeds, writing simulated legal processes, larceny, counterfeit public securities of the United States. Now, researching the proper procedure to have the military arrest them. Please advise. So again, you have to understand, I'm doing mine a little bit different than if I was just trying to get my benefits. Right? I'm making a statement that the people who claim to run the government aren't who they claim to be, and therefore the United States military has a duty under Title 10 to enforce the laws of the United States, and that technically we are already, and Lindsey Graham and Justice Kavanaugh both agreed we're under the laws of armed conflict right now. And if we're under the laws of armed conflict, then F Field Manual 27-10 rules the laws of land warfare. Right? We're not under the Constitution right now. The Constitution has been suspended since 1863. When President Lincoln suspended it, when he suspended habeas corpus. And the way the Lieber Code is written in Article 2, the Lieber Code, it says that once martial law has been declared, it can only be rescinded by a special proclamation or a peace treaty. And neither of those exist from the Civil War, and neither of those exist from World War I. So we have wars going on without peace treaties, so the martial law is still in effect all the way back to 1863. So anyways, what you're supposed to put in here then, right, this is the idea, you're going to put in here, what's your reasons to say that you would be giving these benefits. So I just said, well, I accept the established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow a substantially gainful occupation by reason of service-connected disabilities shall be rated totally disabled. I seek to obtain extra schedular consideration for individual unemployability status and retroactive pay. Be sure to ask for your retroactive pay. I am incapable of securing, following, or participating in substantially gainful employment. I was not properly informed of my needs entitlement or how to claim it, and I claim now that I was incapable of claiming it before. I also need retroactive pay for all previous years of non-substantial gainful employment that I am entitled to. I suffer from chronic adjustment disorders, mental anguish, and spiritual turmoil resulting from my indoctrination by the United States in duty, honor, country. The United States is under attack by domestic terrorists and belligerents engaged in insurrection and rebellion within the territorial boundaries of the United States. My country and my future are in the control of satanic sock puppets disguised as attorneys at law, judges, elected officials, bankers, accountants, international conglomerates, and the like. My condition will only worsen until I figure out how to have them arrested by the United States Armed Forces for their treason and other felonies against the United States. I also suffer from hearing loss, ringing in ears, arthritis, poor eyesight, reduced breathing capacity, frequent congestion caused by environmental irritants, all of which first manifested or worsened while on active duty. That's my statement. I'm not expecting anybody else to have a statement like that, but hey, it doesn't matter. Right? That's what I have to say. So those were the two forms that had to go in, along with your evidence. And so your evidence would be your DD 214, if you haven't ever put one in before. What else there is right, this request for employment information in connection with claim for disability benefits, which is the 214192. You would just send it to whoever it goes to. Tell them to submit it. I can't really speak on it. I didn't do one. And then statement in support of claim. And again, all the same stuff. And basically, I said, I accept in good faith established policy of the Department of Veterans Affairs that all veterans who are unable to secure and follow a substantially gainful occupation by reason of service-connected disability shall be rated totally disabled. You'll find that in 38 CFR 4.16b. And to attain extra scheduler consideration for individual unemployability status by the Director, Compensation Service. I accept this offer. I have need of this compensation, including retroactive pay, for the prior years of non-substantial gainful employment. Because what they put in, 38 CFR 4.16b is an offer. They said, that's the policy. Okay, well, I accept your policy. Go ahead and give it to me. I am incapable of securing, following, or participating in substantially gainful employment. I have not been employed since 2002 and cannot complete the Form 4192. I am requesting retroactive pay. I request the department please expedite a positive decision in my favor. You need to ask for things. Ask and it shall be given. I suffer from chronic adjustment disorders, mental anguish, spiritual turmoil, resulting from the indoctrination of the United States into the country. I'm a veteran bound by oath of office, not a false accusing enemy of the United States, masquerading as a licensed professional or public official of the United States or of the several states. The United States is under attack by domestic terrorists and belligerents engaged in insurrection and rebellion within the territorial boundaries of the United States. Control of my country and my future have been unjustly seized by satanic sock puppets disguised as attorneys at law, judges, elected officials, bankers, accountants, and the like. These belligerents conceal their full legal name from oaths of office, and that is a public security, using a fictitious form of their name, resulting in a counterfeit public security of the United States, and that is a felony. My condition will only worsen until the belligerents are arrested by the United States Armed Forces for treason and other felonies against the United States in accordance with Title 10 United States Code. That would be chapters 13 and 15, which both have to do with insurrection. That's quite interesting. How come there's two titles or two chapters in Title 10 having to do with insurrection? I also suffer from hearing loss, ringing in ears, arthritis, bad vision, reduced breathing. End of statement. Okay, so I sent that form in. I sent that form in, the 526. And this one on the 16th by fax. And I hadn't heard anything. And I tried to do the stuff online and I couldn't get my password to work. And I was working with the people to do that. And I said, I'm just going to call them and ask because I do have a way to call directly. And I did. And that's when they had told me that, yeah, they had sent a letter out 2 days prior, which I haven't gotten from them yet. And on it, it said that they were looking for this employment form for me, right? Which would be, well, them telling me the things they need from me for me to finish, or for them to, finish my claim. And then it says, and it looks like they're getting your records from your military records, which is the other thing it said they would do. So, in my way of thinking, they've already done the part for me for the 5103. So now I'm just waiting to see what they have to say. I wanted to get that form. Yeah, I wish I had all this stuff here, but I don't have it set up here. Hang on a second. This is what I'm talking about, the 5103 notice. 38 USC, United States Code 5103. So you got 38 CFR, Code of Federal Regulations, and you got 38 USC, United States Code. It's 38 USC, United States Code 5103 that says I got to send you this notice. To claimants of required information and evidence. But what they did is they combined that into this easy form. And, why they did it exactly, I don't really know. But that's what they did. And that was, where was that at? That was right here. Well, they put this letter out some time ago where they're going to be implementing some sections of, a public law, 112, 154. I don't plan on reading this. I'm just saying, that's what they did. They've been tweaking it. And part of the tweak was to come up with this easy form where you're already getting the notice. It's telling you what to provide them. And if you just follow what it says, well, then there's really nothing else I need from you. I didn't send in a employment form because I haven't worked. And that was the thing they asked for. But I guess I could have sent the form in and said I haven't worked and put it on there. And maybe that would have been smarter. But nevertheless, it's already done. So, okay, well, this is, like I said, part 2 of a 2 or 3 part video, and I'm going to stop here and go to the next part or call it a day. You'll know if there's anything after this. So everybody have a great day. See you. Okay, part 3. Unemployability isn't a 4-letter word, but changing the military's mind. If you're still watching this video, wow, good for you, because I know it's been quite long by now. The second section was over an hour long. But hey, this is work. This isn't playtime, right? If you want to let your mind turn to mush, go watch the History Channel. But we're talking about big problems that takes a little bit of time to figure everything out. And so why would this be important, right? I don't know that it is. I'm just going to show you that you can change the military's mind. So if you think that you've gotten a bad deal before from the Veterans Administration, well, there's reasons to appeal and take the right information to them. Now, this has nothing to do with the VA. This has to do with the military records. But let's just take a look. So there's a section under Title 10 of the United States Code, and that's for the Armed Forces, right? Title 10 United States Code has to do with the Armed Forces. Chapters 13 and 15 have to do with insurrection. That's what everybody should go read. Been in the military, because that's what we're in right now. We're suffering from an insurrection. But there's this thing about correction of military records, right? And in section 1551, correction of name after separation from service under an assumed name. If you don't know nothing about Rob Ryder, it's all about the assumed name that they give people. That nobody is being recognized in what is considered their full legal name. First name, middle name, last name, no initials, no nicknames. And so what they said is the Secretary of Military Department concerned shall issue a certificate of discharge or an order of acceptance of resignation in the true name of the person who was separated from the Army, Navy, Air Force, Marine Corps honorably or under honorable conditions after serving under an assumed name during a war with another nation or people upon application by or on behalf of the person and upon proof of his identity. However, a certificate or order may not be issued under this section if the name was assumed to conceal a crime or to avoid its consequences. So my whole reason for doing this was to get the military to agree with me what my freaking full legal name was. And so what I had done, because on my original discharge from 1983, after my first tour, they had given me a certificate that said Rutluski, Robert Allen. And this doesn't have a comma, which that's interesting. A lot of times they put a comma. That's to show it's a corporation or a business, according to Dunn's and the United States government. But without a comma, well, that's just the way the Jews write things. They write from right to left. And Robert Allen is my given name. It's not a first in the middle, so they wouldn't be switched. That's just my given name, my last name. Well, Ritluski Robert Allen, to me, that's not my full legal name. My full legal name, according to 6 CFR, Code of Federal Regulations, Part 37, having to do with the Real ID Act, is Robert Allen Ritluski. And I wanted that changed. And so I did some paperwork, and hey, they changed it and issued me a new one. And so what was that all about? How did that come about? Well, first I had read this law, and I said, well, I want to see if I can make them do it. And so I wrote a complaint. By God, they actually have a complaint. Application for correction of military records under provisions of Title 10, United States Code 1552, which is actually this next one. Here's the, you want to correct your name, and then 1552 has to do with correction of military records. All right, so they have a form to do it on. And so I said, I'm going to go ahead and fill this thing out. Of course, they said name, and then it has in parentheses, last, first, middle. That isn't my name. My name's Robert Allen Ritluski. They'll figure it out. I'm going to put it in that way. Present or last pay grade, unknown. Service number, unknown. I didn't know the stuff at the time. I knew my social security number. I didn't know what my present status was because they weren't using my name. Didn't know what my discharge was. I didn't know anything because they're not using my name. That was my thinking as I was filling this form out. So I request the following error or injustice in the record be corrected as follows. In accordance with provisions of Title 10, U.S. Code 1551, correction of name after separation from service under assumed name, the Secretary of the Military Department concerned shall issue a certificate of discharge or order of acceptance and resignation of the true name, in the true name of any person who has separated from the Army, Navy, Air Force, Marine Corps honorably, under honorable conditions, after serving under an assumed name during a war with another nation of people upon application by or on behalf of the person and upon proof of his identity. However, a certificate or order may not be issued under this section if the name was assumed to conceal crime or avoid consequences. Hey, I think that was right out of the law. I just quoted the law. And then I said the DD4, Form 4, is constructed to mislead an enlistee to acknowledge their name is last, first, middle, an intentional adulteration of their true name to ensure future benefits due service members, veterans, and retirees is diverted from to the use of unknown others. Instead of a DD 256 being issued, a simulated document 256A is substituted to cloud the chain of title and leaving my present status unknown. Turns out this 256A, that's used for the reserves. So I'm still trying to figure this out now because it's like, well, if you look at my certificates, they say I was discharged from the USAR, which would be the United States Army Reserve. Well, I was never in the United States Army Reserve, as far as I know. I served 8 years active duty. I beg to differ. I was in the regular Army. Nevertheless, I'm doing my complaint. I believe the record in error or unjust for the following reasons. There is no statutory definition of war. And by a conventional definition, the United States is always at war, either declared or not, such as an ongoing insurrection by an unconstitutional elected and appointed alleged officer of the United States. My faithful time in service under the assumed name Ritluski Robert Allen or Robert A. Ritluski or Ritluski Robert A. or any other bastardization of my true name, i.e. Robert Allen Ritluski, is an injustice requiring your immediate action to provide my equitable remedy. Please correct all official records to reflect my faithful service to God and country in my true name, Robert Allen Ritluski, and issue the certificate or acceptance required in accordance with 10 U.S.C. 1551 and any other remedy available to ensure I receive all entitlements due me by law. In support of the application, I submitted a DD 214 and my original backwards piece of paper, and my certificate of baptism, which is issued in my true name, Robert Allen Ritluski. My counsel is the Virgin Mary. She's my advocate. and my address and da 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 da. Right? So I'd sent this in, and I didn't really know what they were going to do with this. Is this was back some time ago. What was the date on this? I didn't have a date. It was like 2016 I did this. Anyways, I get an answer from the military. Now, they sent it to Robert A. Rutluski, which, again, that bothers me because I don't have a middle name, but let's just go with it. And here I was Rutluski, comma, Robert A., right? And now I'm Robert A. Rutluski, and they're not doing my address the way I do, and so forth and so on. But nevertheless, the Army Board of Correction Military Records rendered a decision on your application to correct your military records. Full relief to your request was granted. Enclosed is a copy of the record of proceedings of the board for your information. The approved record of proceedings has been forwarded to the Army Review Board agency. They will take action to correct your record and provide you official notification as soon as the directed correction has been made. So, what did that mean? Well, back in 2017, I had a docket number. Now it's Rutluski Robert Allen. Right up here, it's Robert A. Rutluski and Rutluski, comma, Robert A. You can see why, they're not using your legal name. Say, well, you're not talking to me. This is the shit they do. They don't use your legal name. First name, middle name, last name, no initials, no nicknames. Right? I didn't define it. The federal government did. The board determined the evidence presented is sufficient to warrant a recommendation for relief. As a result, the board recommends that all Department of Army records of the individual concerned be corrected by issuing his 2 February 1983 honorable discharge certificate with his name showing his signature order. First name, middle name, last name. That's what they decided. And in the case of Rutluski, comma, Robert Allen, application for correction of military records. And basically, this is just, outline what the 1, 2, 3 was for the hearing. Right? That I wanted to show my true name. And the applicant states that showing his last name before his first name is an adulteration of his true name on his honorable discharge certificate. He believes his honorable discharge certificate is wrong because he did not sign a DD-214 issued on March 16, 1988. Consideration of evidence. Title 10 United States Code provides that application for correction of military records must be filed within 3 years after discovery of alleged error or injustice. This provision of law also allows the Army Board of Corrections military records to excuse an applicant's failure for timely file within 3 years statute of limitations if the ABCMR determines it would be in the interest of justice to do so. While it appears the applicant did not file in time frame provided in the statute of limitations, the ABCMR has elected to conduct a substantive review of this case, and only to the extent relief, if any, is granted, has determined that in the interest of justice to excuse the applicant's failure to timely file, and that all other aspects there are insufficient basis to waive the statute of limitations for timely filing. Okay, so basically they're just agreeing with me that they're gonna, even though I didn't do it in their time frame, that I got a substantial reason to have it reviewed. I gave them probable cause to do a review. And sure enough, they looked at the paperwork and, without boring you with all these details, I mean, if you want to read it, just stop right now and take a picture, right? Read it. And I'll scroll down some more and you can stop and read the rest. And I'll scroll down again and you can read some more. All right, so what was this discussion? The applicant's 2 February 1983 honorable discharge certificate was improperly prepared. They agreed that Rutluski Robert Allen is not my true name. And so they issued a new certificate as Robert Allen Rutluski. Now it's in all caps, which that's its own little Ricky Lake story that they mention in their review. But I wouldn't have all these things to contemplate had I not done this, right? So now I can ask, well, why did they put it in my full legal name? Right? According to the governing regulation, his name should have been entered in signature order in capital letters. Well, regulation says to put it in caps. Right? So, anyways, cool. They agreed with me and they issued a new document. And so you can change the military's mind, right? When you point out to them what the law says. And that's why doing this thing with the VA, if we can just get them to tell us, okay, well, send me the 1503 letter or whatever the hell it is to see what I still need, and I'll get those things take off. I'll ask for extra scheduler consideration and, look for some equity. Okay, that's the end of this video, and thanks for watching. You have a great day. See you.